to adjourn. Okay? No problem. Good luck. Okay. Back into the agenda. Give me one. It's hot in here and it's been great.
Yeah, it was warm in here yesterday too. We do have 2 homicides.
I believe 2 exams. I don't know what they are. I just got this sheet.
It's not a homicide case. So
We may continue homicides.
I don't think so. But I think Barry King is in trial. Sure, if he would be done.
Oh, okay.
Morning, Mark.
Hey, good morning. How you doing?
Morning.
One homicide.
Okay.
4 PCC.
Yeah.
That we had yesterday was.
I was a homicide case. 1:30.
Good morning, Ms. Casper.
Good morning, Judge. How are you doing today?
Doing well, thank you. How are you?
I'm doing great. I'm doing great.
Good.
And my client's on, and we're ready to go whenever the court is at your service.
Okay.
Yeah, yeah.
We made-
This one, I think it's what it says.
I mean, wait,
Yeah, this way you want.
Okay, fill that out.
Yeah.
trying to help them. That's why I can't help. Okay. After one.
Okay, we're ready on Lon Smith.
Ready, Judge.
Calling case number 230-592-9201. The people of the state of Michigan versus the defendant, LaDonna Smith. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, domestic violence, second offense notice. domestic violence and or knowingly assaulting a pregnant individual, second offense notice, set for probable cause.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. May it please this most honorable court, Nicole Casca, P 55470, on behalf of Ms. Smith. Ms. Smith and I are present on Zoom. Ms. Smith, can you please state your full name for the record and that you do consent to having today's hearing by Zoom?
Lon Smith, I do consent to having this arraignment on Zoom.
What's your pleasure, Ms. Casper?
Judge, I did have an opportunity to go over the discovery as well as watch the videos. There's one video that's missing, but I don't need it in order to have the conversation and make the decision with my client. At this time, Judge, we are asking for a preliminary examination date. Perhaps Ms. Drain can make sure that I get that, whatever the next door neighbor's surveillance video. He's one of your witnesses listed on the witness list that was in the discovery. If we could please have that before the exam date, that would be great.
I will.
The court will continue to plead not guilty and set this matter for preliminary examination. How is October 25th at 9:15?
Not good for me, Judge. I've got two final conferences, both on capital cases over at Frank Murphy. I could do later in the morning. Like, do you have something like maybe after 11 o'clock, 11:15?
Okay, October 25th at 11:15.
Thank you, Judge. Appreciate it.
Will be continued.
Thank you very much.
Thank you.
Ms. Smith, we can exit the meeting. I'll be in touch.
Thank you.
Okay, thank you, everybody. Be safe.
You too.
Mr. Pitts?
How you doing, Your Honor?
Okay, we're just waiting on your attorney.
Okay.
Y'all on Zoom?
No.
Client just checked in, put me in yesterday. Y'all were told to check in today. Christina, Jones.
Okay. Thank you. Morning, sir. Can I help you?
Good morning, Judge. We have a client that's currently in the Detroit Detention Center. It says on the register of actions you were going to be the judge. I don't know if for today.
He's in DDC. Sounds like he needs to be arraigned. I don't do arraignments.
Okay. Do you know who I would go to?
Whatever magistrate is doing arraignments today.
Okay. You wouldn't happen to know who that would be, would you?
Offhand, I don't.
What would that be? One?
Hang on a second.
I appreciate it, Judge.
Magistrate Eshartea.
Magistrate, pardon me on that one?
Eshartea.
Sartan?
Eshartea.
Okay. I will see if I can. You wouldn't happen to have a Zoom ID, would you? Sorry for all the questions.
360-134-0000.
Thank you very much, Judge. You guys have a great day. Appreciate the help.
You too. Mr. Dupree, good morning.
Good morning, Your Honor.
You here for Mr. Pitts?
Yes, Your Honor.
Okay.
Calling case number 230-593-7901. The people of the state of Michigan versus the defendant, Shant Pitts, AKA Shant Pitts II. The defendant is being charged with count one, assault with intent to great bodily harm, less than murder or by strangulation. Count two, domestic violence. Separate probable cause today.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. May it please the court, Matthew Dupree, P80132, attorney for the defendant. Mr. Pitts, would you state your name, please?
Shant Pitts.
What's your pleasure?
Shant
Mr.
Lamar Pitts, I'm sorry.
What's your pleasure, counsel?
Judge, at this time, we would just ask to schedule the matter for preliminary examination.
That was October 27th at 9:15.
Give me just a second to check. Judge, I've got about 8 matters in Frank Murphy on the 27th. Is there any chance we could push into the next week?
October 30th at 9 o'clock.
Give me 1 second to check that, Judge. Is there any chance it could be later in the morning than 9 o'clock, Judge? I have an 8:30 in Southgate. I think I'd be back by 9, probably by 10, but 9:30 might be a little early.
October 30th at 10.
Thank you, Your Honor.
Yeah, October 30th at 10 o'clock, following the continue.
Thank you.
Judge, actually, could I address bond?
Okay.
Your Honor, we would move to amend the conditions of bond to remove the tether. The defendant was ordered on tether while the case is pending. He doesn't have much of a criminal history. I think a single misdemeanor drug offense from a number of years ago. He's worked for 5 or 6 years at Chrysler. He's a high school graduate. I don't think there's a reason to believe that he is a flight risk. He did present himself today. Of course, he's on the tether now, but nonetheless, and I don't think there's a reason to think he's a continuing threat to the complainant. So we'd ask, given that this is a lower end charge, that the tether be removed. Thank you.
Ms. Drain?
Thank you. Your Honor, at this time, I would ask that the court deny the motion to remove the tether. I haven't heard any reasons that the tether needs to be removed. If he needs certain hours to be expanded, if there are prohibitive hours, I wouldn't object to that, but I would object to removing the tether.
And I haven't heard a sufficient basis to remove the tether as well.
Very well.
I'll continue, thank you.
Thank you, Your Honor.
You're all set. Yes, you're all set.
Okay, thank you.
And I think I'm all set too, Judge. So
Okay, thank you.
I'll see you tomorrow.
Okay.
Thank you.
Okay.
No.
John is Pitts on, Zoom?
Familiar Spitz? Very not familiar Spitz. Yes, no. I don't have anybody in my way.
Right.
So I don't think you're on my docket today.
Yeah, Beverly. Yeah, he on.
Oh, very good. I'm sorry. Yes.
Just got a call from officer saying that officer is the wife, Alina, she's on the Beverly case. She's just running 10 minutes late.
Hey, good morning, how you doing? Good. Do you have the APA here yet?
Prosecutor Garland.
Let me see. Okay.
Yes, Beverly. It's a Beverly right here. What it says. Okay. That's the attorney.
Mr. McWilliams,
Good morning, Judge King.
good morning, sir. When you come in with iPad, I don't know who you are.
Okay, I'm sorry. I didn't know that was the case. Usually it comes up with my name.
No, it's coming up iPad.
I'm
Nonetheless, you are here on Charles Williams, is that right?
That's correct. I was assigned to that case. I have some information that comes by way of Mr. Williams' mother that I could impart to the court if that would help.
That's why I don't have a prosecutor. Can you stand in for APA that's doing the Charles Williams case? First degree felony murder. On PCC. Do you know who the prosecutor is? Is it who came on file?
It says, Tina Livingston. Tina Livingston.
I don't know that to be a prosecutor.
That's that prosecutor.
I mean, I could stand in, I just, if there's a conflict of engagement. That whoever's in.
I'm gonna put it on your doc. Thank you.
Unknown caller.
Hello?
Let me see the chart. Are you able to figure out who that belongs to?
There's no number or anything. It says, I'm gonna.
Still connected to there.
Tina Livingston signed the warrant. Tina Livingston signed the
I don't
warrant.
know who that is.
And Mr. Gallo is here. You can have that dependent step in. Good morning, Ms. Diallo.
Good morning, Judge. How are you?
Good, and yourself?
I'm wonderful. I do think
Yes, we found late yesterday afternoon. Yeah, look what we found late yesterday afternoon. Here she comes now.
that would be, yes, that's her, Miss Jones, Christina.
Yes, ma'am.
All right. Call Christina Jones.
Okay. Calling case number 230-5919401. The people of the state of Michigan versus the defendants. Christina Jones. The defendant is being charged with count 1, assault with intent to create bodily harm less than murder or by strangulation. Count 2, assault with a dangerous weapon, felonious assault. Count 3, domestic violence.
Appearances for the record, please. Go ahead.
Lillian
Ms. Diallo.
Diallo. Thank you. Lillian Diallo, P52036, on behalf of Miss Christina Jones, who is physically present in front of Your Honor, with apologies.
Ms. Jones, tell me your name for the record.
Christina Denise Jones.
Ms. Jones came here yesterday at exam. She showed up late, 2 hours later, after her case was called, indicating that she had issues with the bus.
Okay, so Judge, if we could just reset this matter for a preliminary exam now that we have her before the court. I had spoken with Ms. Drain about certain options in this case. We don't necessarily believe this case will be moving forward. So if you can just set it down for a preliminary exam at Ms. Drain's convenience, I'd appreciate it.
All right, the court will continue to plea of not guilty and set this matter for preliminary examination. We'll do October 20th at 10:30. I'm sorry, wrong day. October 27th at 10:30. You're on mute, Ms. Diallo.
That's a good date, October the 27th. Now, Ms. Jones, you know that means you got to come down to court here.
Yes, ma'am.
At what
Ms. Jones,
time, Ms. Jones?
if we have some issues with the bus again, I'm gonna keep you next time, so you won't have a problem getting here timely. Do you understand?
Yes, Your Honor.
Okay.
Thank you so much, Your Honor. It's always a pleasure to see you, Ms. Jones. We'll talk. Everybody take care. Bye, Mr. Pitts.
Thank you, ma'am.
Bond reinstated. Thank you.
Bye.
Tell me what the first name on the road was. This was
Charles.
She still didn't know.
Can I ask for his birthday too? There's just not a Charles.
June 20th, 97. Charge of felony murder.
Judge, it looks like it's unsigned. So
Okay,
I think all we do is have to stand.
all right, we call it. Calling case 2358899, the state of Michigan versus Charles Williams.
Good morning, my
Defendant is charged in count 1 felony murder, count 2 felony firearm, count 3 assault with intent to murder, count 4 felony firearm. Appearances for the record, please.
Good morning, my client, people, consider 928.
Can't hear you, Mr. McWilliams. You're on mute, sir.
Thank you very much, Your Honor. Attorney John McWilliams, P17565, on behalf of and assigned to Mr. Charles Williams, Jr.
And are you waiving your client's appearance for purposes of this hearing?
Yes, as I understand, he's in the Oakland County Jail.
Okay. Court will waive the defendant's presence. What's your pleasure?
Your Honor, I know he's going to be sentenced, I understand, for a lesser charge than it's before the court at the present time on October the 26th. I would suggest that we probably should go off probably until November the 2nd. If that would be convenient for the court, we'll find out where we're at then.
November 2nd for an exam?
I think if we better set it for a adjourned PCC, see where he's at.
When does he come up for sentencing?
The 26th of this month, week from today. And this is information from his mother. I didn't receive it from any court official.
I can do November 2nd for an exam.
Well, that'll be just fine then.
Okay, November 2nd, 2023. What time works best for you? 10, 11:30, or 1:30?
11:30, Judge?
November 2nd at 11:30?
That'd be fine.
File will be continued. Thank you.
Thank you, sir.
All right. Geron Beverly. case 2359027, people of the state of Michigan versus Geron Beverly. Defendant is charged in count 1 operating license suspended, revoked, denied, causing death. Appearances for the record, please.
Good morning, my today.
And may it please this honorable court, good morning, Myron Pittsburgh, on behalf of Mr. Beverly, who stands at the defense table to my left, ready to proceed.
Tell me your name for the record, sir.
Geron
There's the date and time set for preliminary examination. Are you ready to proceed?
Yes, Your Honor.
How many witnesses will you?
Sure.
Any preliminary matters before you begin calling witnesses?
Yes, Your Honor, I have a medical examiner's report, post-mortem report, dated October 11, 2023, and I was moved for the admission of that.
Any objection?
I have no objection.
Admitted.
And Judge, to summarize, the report indicates that on September 11, 2023, regarding victim Luther Philly law, the report indicates that it's my opinion that death was caused by multiple injuries with complications. The decedent was a pedestrian struck by a motor vehicle on August 18, 2023. On admission to the hospital, he was found to have multiple cranial cerebral injuries, subdural and subdural hemorrhages, fractures to the right temporal lobe and middle of the cranial fossa, hematomas, and bilateral frontal and right temporal lobes. And cerebral edema, for which he underwent decompressive left craniectomy. He developed ventilator-dependent respiratory failure, pneumonia, cardiovascular facilities, anoxic encephalopathy, deep venous thrombosis and to the lower legs, and saddle pulmonary embolism. He was pronounced dead 23 days after admission. The report further down indicates that complications present at autopsy indicated anoxics, pneumonia, multiple peripheral pulmonary emboli, and renal abscesses. The manner of death was an accident. Judge, I also have people's proposed exhibit 2, which is a certified driving record. And I would move to the admission for that as well.
Any objection?
Sure, no problem.
Admitted.
Thank you, Your Honor. And that our driving record indicates that the license of Geron Beverly, date of birth 1/19/1996, was suspended at the time of this accident. And with that, I have no further preliminary matters, so I'd like to call Officer Beverly.
We have a
I think we're
identification of the complaining witness.
Sorry?
Identification of the complainant. So we have the snips of the identification as being Luther Philly.
Yes, Your Honor. I apologize. I thought I mentioned that before I read the report.
So stipulated, Mr. Pitts.
yes, Your Honor.
See that stipulation.
Your Honor, I'd ask for a mutual sequestration order. I'm not sure if this is a family member of the decedent. Fair enough. But I would ask for a mutual sequestration.
All right, ladies and gentlemen in the audience, if you are a witness or potential witness, I'm ordering you to leave the courtroom at this time. If you stay, knowing that you are a witness, may prevent you from testifying at a later date. Also, people out there in YouTube land, if you are a witness or potential witness, I'm ordering you to log off.
One moment.
Sir, please step forward, give your name and spelling to the court report. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you, Judge. Please have a seat. The witness box is. Maybe begin when you're ready. Thank you, Your Honor.
Can you tell the court how you're employed?
As a detective with the city department. Let us get his name first.
I'm sorry, did you say your name again?
Detective Shabbat.
How are you employed?
As a detective with the city of Detroit Police Department.
Okay. And were you with the department back on August 18th, 2023?
Yes.
And were you on duty that day?
Yes.
And did you respond to an accident that brings you here today?
Yes.
Okay, do you remember the location of where you responded to?
Yes.
What was that?
Wyoming and Gray Road.
Okay, is that in Detroit, Wayne County, Michigan?
Yes.
Okay, and when you got there, did you come into contact with anyone you see here at the court today?
Yes.
And could you indicate where that person in the court was sitting?
Yes. A young man.
Let's take the latest.
Thank you.
Okay, and what did you observe when you arrived on the scene?
When I arrived on scene, I observed a vehicle that was on the scene, and I believe there was a person. I believe he was outside his vehicle when I arrived.
Okay, do you remember what kind of vehicle it was?
Yes.
What kind of vehicle?
It was a Chrysler Stand.
Okay. And where was that vehicle located?
I believe it was on the side of the road when I arrived.
Okay, which road was it on?
Wyoming.
And did you observe any damage to the vehicle?
I would have to review my notes, but I don't recall the exact damage from the vehicle at this direction.
That's okay. So you came in contact with the defendant?
Yes.
And did you speak to the defendant?
Yes.
Okay, and did you eventually take a statement from him?
Yes.
And before doing that, did you read him his Miranda rights?
Yes.
Okay, and did you use a form to do that?
Yes.
Judge, we have a question?
Yes.
People's proposed exhibit 3 to you. Do you recognize that form?
Yes.
And what is that?
It's a constitutional right certificate of notification.
And what is that form used for?
This is a form used to advise people under Miranda before we conduct an interrogation.
Okay, and is that the form you used on this date?
Yes.
With this defendant?
Yes.
And did you go through the entire form?
Yes, I had him read each right and initials that he understood each right as he read them.
Okay, and did he also sign that form?
Yes.
All right. And do you recall you read it himself or if you read it to
I believe he read them himself.
and he indicated that he understood each one? Is that
Yes.
right? The people would move for admission of
Any objection? None, Your Honor. Admitted.
and after you went through that, did you give a statement?
Yes.
And was that statement recorded?
Yes.
Judge, I'm trying to share.
Are you getting into the statement?
Yes.
Mr. Pitts, do you have any voir dire for commentaries? Purposes of this hearing, the court makes a finding that the statement was knowingly and voluntarily given to be pursued.
Judge, I'll indicate that this section is for and this starting 2 minutes, 6 seconds.
So you're moving for the admission?
I was going to play a few seconds for.
Lay the foundation.
Yeah. Play it two.
Confirm that you saw this form, it was acknowledged. Put the date.
I'm not sure what is this? This is being played for the admission of the state, right? If that, I have no objections to it. It's not being played for the admission of, for the purpose of putting the state into the record. I'm not sure why it's not played. So I object without.
My understanding is that he was laying a foundation, he was gonna have the officer testify that this is what, or excuse me.
Okay, fair
Thank you. Do you recognize that video I just started playing?
Yes.
And is that you in the video?
Yes.
And is that the video?
Yes.
And was that you giving him the statement you were just referring to, signing the form you were just referring to?
Yes.
And this video an accurate function of the statement, is that it?
Yes. Any objection?
None, Your Honor.
Admitted.
Judge, it's a pretty short video. I'd like to play it without starting at 3:07.
Which is the 18th, 8/18/23. The time is, I mean, he's still out.
I mean, yeah, but I hope he do better tonight, because I know it's awful.
So, yeah, look, bro, what's up? I'm in the interview now at 8/18/23. The time is 10:12 a.m. What's your name, man?
Geron Beverly.
Spell that for me.
Jarohn.
That?
Capital R, but yeah.
Oh, it's like apostrophe capital R?
No, it's just capital R.
Just capital R. Beverly?
Yes, sir.
Date of birth?
1/1996.
Address?
8262 Rosemont Avenue. That's on file.
You said
8262 Rosemont Avenue.
Detroit?
Yes, sir. 48228.
Phone number for you.
313-656-9975.
All right. All right, but like, before I ask you any questions about the crash, you do have to advise you of these constitutional rights. What's the highest level of education you got?
Like some college.
Some college? Mm-hmm. All right, can you start, read?
Sorry, I skipped that.
You gave me any statement or anything. It's just saying that, you know, before I ask you about the crash advisor. So just sign, which is confirm that you saw this form. It was acknowledged. Put the date, which is the 18th, 8/18/23. And then the time is 10:09. Alright, now I'm about to ask some real stupid questions. Alright, I'm talking, these questions sound stupid, but the first question is, do you wish to tell me what happened today?
Yes.
Alright. Now I'm going to go through a whole shindig of, I'm Detective Dodger, Detroit Police. I'm investigating a car crash that happened in the area of Dre Road in Wyoming. I'm talking to
Geron Beverly.
Alright, Mr. Beverly, do you understand I'm investigating a car crash?
Yes.
Alright, that's the first stupid question. Alright, and were you involved in the car crash?
Yes.
How were you involved in the car crash?
I hit the pedestrian.
Alright, you say you hit the pedestrian. Run through the events.
So, I'm leaving Hometown Market on my way home. This train that I seen like a beige and like he was coming like right before he hit the light. So I wanted to make him, I wanted to get in front of him before I could go ahead and go. Yeah. Make that turn on my camp and go home. But like as I'm turning, I'm already crossing the lane that's going, that's east, going on east on Wyoming. And I got on my, I hit him like this. And I see him, but he was on top of my,
on this side of the wind. I'm trying to sit on this side of the wind.
Yeah, as I turn, like he's on top of that's the next thing I know is he's really on top of my bumper. I mean, not my bumper, but my windshield.
He was on your windshield?
In the middle lane. Yeah, middle lane. So as I pull over and see that he got hit, I goes and go shake him and see if he okay.
Alright, you stayed on scene and waited for the police?
The whole time.
You identified yourself to the police as the driver?
Yes, sir.
Alright. Any alcohol today?
No. I just got off work.
Huh?
I said just got off work.
Any narcotics? You got a valid license?
Sort of.
What sort of?
Sort of. Well, I just got like a few tickets in Detroit.
Is your license good or bad?
Right now it's bad.
Bad? How bad? Like a hard suspension? Like bad? Like OWI suspension? Or
Ain't no OWI.
Just ticket suspension?
Just ticket suspension.
Alright. And then, do you remember how fast he was going?
No. Couldn't have been that fast. I was just coming out because I just came to a stop because I looked both ways. So I couldn't be going too fast because I just seen the car on Through Road in Wyoming about to come. So I wanted to make sure I got in there and had enough time to look both ways to see how it was going to do.
Anybody else in the vehicle with you?
No.
Nobody else in the car?
Nobody in the car.
Anything else to add that you feel like I didn't add?
No, that's pretty much it. I hope he okay. I really do.
I mean, you still alive.
I mean, yeah, but I hope he gets better. Like, I know it's
So, yeah, look, bro, what's up? I'm in the interview now at 8:18:23. The time is 10:12 a.m.
Approaching the people's things at the time. Handing you a photograph. You recognize that?
Yes.
And what is that?
This is the Chrysler sedan mentioned earlier.
Is that the car that was in the developing car crash?
Yes.
Is that an accurate description of the something? Right.
Yes.
People looking for spot.
No objections. Admitted.
I don't have any.
Please court. Detective Najah Ray. Najah. Good morning to you, sir. Listen, you responded to the area of Joy Road in Wyoming anytime in question, correct?
Correct.
You conducted an interview with Mr. Beverly, fair statement?
Correct.
Some of that interview we just saw on the video, correct?
Correct.
Pursuant to that video, you learned that Mr. Beverly was leaving a market area.
Correct.
Okay. That he looked both ways when he left the marketing area before he entered the causeway, correct?
Correct.
Okay. That you have no evidence that he was speeding, correct?
Correct.
Okay. He's making a proper turn onto Wyoming, correct?
Correct.
So from what you learned, other than the fact that he had no driver's license, he was following all appropriate traffic laws in the state of Michigan, correct?
Correct.
Nothing further, thank you.
Can you redirect?
No, Your Honor.
Ms. Kleinfeld, can you run that back to 35 minutes from when the defendant was given the explanation as to what took place?
What's your name? All right, Mr. Beverly, you understand?
I'm leaving home. This is turning out seems like a beige semi
Crash.
I hit the pedestrian.
All right, you say you hit the pedestrian. Run through the events.
So I'm leaving hometown market on my way home. This turning out seems like a beige semi keeps coming like right before he hit the light. So I want to make him. I want to get in front of him. I can already go. Just make that turn on my campus and go home. But like as I'm turning, I'm already crossing the lane that's going. That's east going on east on Wyoming. Man, like got on my, I hit him like
This side of the wind. I'm trying to sit on this side of the wind.
Yeah, as I turn, like he's on top of that. That's the next thing I know is he's really on top of my bumper. I mean, not my bumper, but my windshield.
He was on your windshield?
In the middle lane.
Yeah.
In the middle lane. So as I pull over and see that he got hit, I goes and go check him, see if he okay.
You stayed on scene and waited for the police?
The whole time.
You identified yourself to the police as the driver?
Yes, sir.
All right. Any alcohol today?
Any got off first.
Huh?
Judge, I did have one more question before submission.
Go ahead.
One or two more. Pursuant to your investigation, Detective Dajarat, okay, you learned that the person who was hit was a Mr. Filia.
I'm sorry, I don't recall.
Okay.
Fair enough. And you learned that when Mr. Filia was struck by the vehicle driven by Mr. Beverly, Mr. Filia was not crossing the street at a crosswalk, correct?
I'm unaware of where the victim was actually at.
Fair enough. If you're familiar with the scene sketch that was done, correct?
Correct.
Okay, if I showed you the scene sketch, might that refresh your memory as to where Mr. Filia was at the time he was struck?
Yes.
So I don't know if he has personal knowledge. Were you there at the time he was struck?
Yeah, yes, I did the scene sketch.
Oh, you did the scene sketch.
What he's holding is the crash report.
Well, are you familiar with the crash report?
No, the scene sketch, no, yes.
At any point that you learned that Mr. Filia was not crossing at a crosswalk when he was hit, the decedent?
Just based off the statement of the defendant, he said he was an attorney. If I can see the scene sketch.
Give me one. You are familiar with the scene sketch, correct?
Correct.
And if I were to show you the scene sketch might that refresh your memory as to the location of the decedent when he was struck?
Possibly.
Okay. With course permission? Yes. Take a look at that scene sketch.
Yeah. He should have like a law right
I'm not sure if I have a law. You have a law?
there. Yeah.
Thank you. So if I showed you the law, might that also refresh your memory?
Yes.
There's a massive continuing permissible approach. Thank you, Brian. Presenting which would force you the law and the scene sketch.
Yes, this way. Yeah.
Okay. Just let me know when you reviewed it and your memory is refreshed. Let me know when you reviewed it and you're done with it.
I'm done.
Okay, fair enough. Is the scene sketch and the log now refresh your memory as to what occurred?
Yes. You want me to explain?
No, I want you to answer my question.
Oh, yes.
My question is whether or not Mr. Filia was crossing at the crosswalk when he was struck. The answer is no, correct?
Correct.
Okay. He was walking in the middle of the street, correct? Fair enough.
Based off the evidence, I can tell you where he landed and the approximate cause of the crash.
I didn't ask you any of that. My question was where he was walking when he was struck.
I can't answer that.
Okay, he was not walking at the crosswalk, was he?
I
Like I said, I can't answer that based off my sketch. I can answer what approximate cause of crash occurred. So I was thinking,
Okay, so you don't know where the crash occurred?
no.
Okay. All right, fair enough.
Do you read her? And Officer Dazaraj, you don't know where the crash occurred because you weren't there. You weren't there present when the crash happened. Is that right?
Correct, Your Honor.
You're able to tell us where the body was found and where the vehicle was found. Is that right?
Correct.
If I follow up, the body was found in the middle of the street, correct?
Yes.
Okay, not near a crosswalk, correct?
Correct.
Nothing further, thank you.
Do you even know how fast the vehicle was going at the time of impact?
No, Your Honor.
Judge, can I ask one question? You just took a look at the field sketch again.
Yes.
And do you recall approximately how far, when you determined where the approximately where the crash took place, how far that might have been from the exit of the store that was located there?
No, I went.
Okay.
So, how long have you been a police officer?
Over 9 years.
And how long have you been assigned to this particular unit?
Over 4 years.
In your experience, about how many cases have you investigated vehicle and pedestrian accident?
Over 200.
In those 200 cases that you have investigated, when a vehicle hits a pedestrian, they fall right where they hit?
No.
Would it be fair to say that depending on the speed of the vehicle, may depend on how far that body is from?
Absolutely.
And again, you don't know how fast this vehicle is going.
No, Your Honor.
How far was this body from the crosswalk?
I would have to look at the log to get the location of blood spot from the reference. I can see the line there and give you exactly.
All right. And that to Mr. Feinberg.
I'm sorry, just the field sketch.
That what you're looking for?
The log is where I put the numbers, so. Yes, I have the reference point of the southeast corner of Dre Road in Wyoming, and the left shoe is 187 feet from the southeast corner of Dre Road in Wyoming, and the low is 231 feet. The blood and the shoe alone have decent distance between them. Well, also, the blood is 231 feet south of the reference point within that intersection. Right?
Any questions based on my question?
Yes, the distance between the blood and the shoes, did that have any significance to you?
Yes, it's a pretty decent distance.
I would ask that he not, Judge, if this calls for speculation, I would object.
The question was that it had any significance. I'll take that. I'll take that answer. You can tell us why it has significance.
They're over 40 feet apart between the shoe and the blood.
What does that mean?
That's a great distance. 40 feet between your shoe and you.
So that indicates what?
Judge, I'm gonna object.
I have to speculate, sorry.
Right. That's my objection. If he's speculating, object. He just said he speculated.
Judge, I have nothing further.
Nothing further. Thank you, sir.
Thank you, sir. You may say.
Your Honor, the people will call Detective Schwab.
Raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Thank you, sir. Please have a seat in the spots. Begin when you're ready.
Thank you. Could you say your name again?
Detective Richard Schwab,
And how are you employed?
City Detroit Police Department.
And you got that department back on August 18th?
Yes.
2023?
Yes, sir.
And did you, were you in charge of investigating a case that brings you today?
Yes, sir.
And where was the location of that case?
Wyoming and Joy.
Okay. And is it safe to say you reviewed all the evidence related to that case?
Yes, sir.
Okay. Did that include video evidence?
Yes, sir.
To your knowledge, was any video evidence retrieved related to this case?
Yes, sir.
Where was it retrieved from?
The location where the accident took place is a green light location located on Wyoming. It's the super grown market, homegrown market. It's a green light location.
Okay. And you had an opportunity to view that video?
Yes, sir.
Okay. And do you recall that video captured the incident that brings it?
It does.
Okay. Judge. I'd like to share my screen again.
All right. I think there's a Mrs. Billiard in the courtroom, is that right?
She stepped out.
She stepped out, okay, great.
Judge, I'm going to play just a few seconds from 8 minutes to 29 seconds. Detective, do you recognize this video?
Yes, I do.
Pausing at 8:30. And do you recognize the silver car in that vehicle?
Yes, I do.
Or in that video? Is that the car that was involved in this car crash?
Yes, it is.
And is this an accurate depiction of the video that you retrieved or reviewed from the line?
Yes, sir.
The people, this is proposed to the 6th.
No objection. Submitted.
Continue playing. Pausing. Again, I know it's kind of hard to see. That video captured the collision.
It did.
And were you able to see that just now?
Yes, sir. But I know I think there's another angle, I think.
While I'm trying to pull it up, so you retrieved multiple videos for this?
I believe there's two videos from that same location. That's the video.
Judge, this is people's proposed exhibit 7. Play a few seconds of pausing. Do you recognize this video?
Yes, sir.
Okay. Is that the same parking lot we were just looking at?
Yeah. Yes, sir. Just at a different angle, closer.
Okay.
Are you moving for submission?
Yes, Your Honor.
Any objection?
None, Your Honor.
Permitted.
Sorry, Judge. Like 8:34, 48 seconds, John. How's it get 8:35, 19? Do you recognize that vehicle?
Yes,
Is that the same vehicle we just saw?
correct, just at a different angle.
And did that video show the collision?
It did.
And did the victim appear to be running or moving quickly into the street?
Objection, leading. We can't narrate. Video itself speaks for itself.
I have no further questions.
Passes out.
Detective Schwab, how are you this morning?
I'm well, sir. How are you?
Listen, you had an opportunity to review two different Project Greenlight videos.
Yes, sir.
And the same video, but from different angles.
Yes, sir.
Okay, and from your analysis of the video, you were able to draw various conclusions, correct?
Yes, sir.
You were able to conclude that speed was not an issue, was not a factor in the crash, correct?
That's correct.
Okay, you were able to conclude that the pedestrian who was stuck, Mr. Filion, was not crossing at the crosswalk, correct?
That's correct.
Nothing further, thank you.
Redirect.
No, Your Honor.
Thank you, sir. You can step.
Thank you. The people that look for the distance.
Can we approach for a moment? Sorry, can we approach for a moment?
Sure. Yeah.
Your Honor, I would respectfully ask that the toxicology report be produced. I think it's necessary as relates to.
Do we have the toxicology? I do not, Your Honor. As I indicated in the previous hearing, the victim was in the hospital for 23 days. Medical records were provided to the ME. I don't know if there's a toxicology report in that.
Anytime there's a homicide, there's a toxicology report. Fine.
I just don't know what the hospital did or what tests were.
Okay, so let's just say, for sake of argument, let's say he was in a drunken stupor. So what?
If he's in a drunken stupor, Your Honor, then that would go to my argument of superseding intervening causation. Number one, what do we know from the testimony? We know from the testimony that Mr. Beverly, speed was not a factor. That came from the last witness. We also learned that, according to the previous witness, Mr. Dajarah, investigator Dajarah, that he looked both ways. Mr. Beverly's looking both ways.
You would acknowledge that Officer Dajarah has no information that would validate that other than what your client said, which is hearsay, not offered by a party opponent.
Totally understood, but bearing that in mind, I do know what came into the record, so I would use that as part of the argument.
This court has to make its ruling based on admissible evidence.
I think we know that the decedent was not crossing at the crosswalk. That alone might give us ordinary negligence, which is not rise to the level of superseding intervening causation, breaking the causal chain, making the actions of Mr. Beverly not the proximate cause of the death of Mr. Filion. However, if Mr. Filion is intoxicated, at the same time he is violating, at the same time he's not crossing at the crosswalk, that gives more weight to the argument that there's a superseding intervening causation, a man who is intoxicated, and we don't know if he is or isn't, but certainly we haven't received the report. He's intoxicated and walking not at the crosswalk. I would argue that breaks the causal chain of the actions, but certainly the factual cause is not having a license, but that's not necessarily the proximate cause, the legal cause of the death. I would say the legal cause of the death has to be measured against the possible gross negligence of the decedent. And I think we know there's at least simple negligence because he's not walking in a crosswalk. If we can combine that with a toxicology that shows his judgment was impaired, that his blood alcohol BAC was above the legal limit, I think that goes to my superseding intervening causation argument. So I would ask that any decision made as it relates to the bind over be held in abeyance until we get the toxicology. Because that would supplement the argument that Mr. Beverly's actions are not the proximate cause, but the gross negligence of the decedent is the actual proximate cause of this passing.
Judge, I think the video makes it clear that the victim wasn't negligent to a level that would be a superseding cause. It's a bright day, the road was clear. He wasn't running into the street, he was crossing the street. Yes, it wasn't at a crosswalk. But the defendant simply didn't see the victim or didn't stop once he did. But I think the fact that he was at an open road and went from a standstill pulling into the road, it was clear that he had not looked ahead to see that someone was in the road. I would ask for that.
If I may respond. The video only shows half the story. The video shows what one from objectively can see. But we're concerned about the subjective mental state of the decedent. If he's intoxicated, and he may not be, but we don't know until we get the toxicology. If he's intoxicated, it certainly goes to his mental state, and it would certainly support the action he has on the road. Our argument is that the actions of the decedent are actually the proximate cause of his death, breaking any causal chain that Mr. Beverly might have as it relates to the decedent's past. We can look at the video and see objectively what's going on, but we cannot make it a subjective determination as to the mental state of the decedent. We know the decedent was not crossing at the crosswalk. If that is combined with the BAC that shows he's legally intoxicated, I would argue that there is more weight to the superseding intervening causation. We can say, oh, he's crossing at the crosswalk, but we don't know what his mental state is when he crossed. His physical state, his mental state. Is he under the influence of alcohol? If he's not, then the argument is moot. But if he is, I think we need to know before bind over is made. We know it's a clear day, which cuts both ways. It's clear enough for Mr. Beverly to see what's going on. It's clear enough for the decedent to know what's going on and to see the oncoming traffic. Notwithstanding that, the testimony was that my client was making a proper left-hand turn. Speed was not an issue. So what is the issue? There's no evidence that my client was intoxicated. Was the decedent intoxicated? Because we know he was not following appropriate traffic laws, while we know from the evidence that my client was. I think it's important to find that out, and I ask that the decision on a bind over be held in abeyance until we get that information.
I don't think it's necessary because let's look at things in the light most favorable to your client. Let's say that the decedent was intoxicated. Even though jaywalking is illegal, you must yield to a pedestrian in the roadway. If they step out into the street ahead of your vehicle, you must keep a lookout for other vehicles yielding to pedestrians in the roadway too. That was not done here, clearly from the people's exhibit. The defendant not only outrank, let's say that he did make a legal left-hand turn onto the roadway. He drove some distance in broad daylight. This wasn't even at night, this was at broad daylight. He drove some distance before he hit the complaining witness. They say speed was not an issue. I can't really tell if it was or not based on the video evidence that I've seen. It looks like he was accelerating. As he was accelerating into the roadway, he hit this man that was crossing the street. Doesn't matter if he was in a drunken stoop. He was crossing the street, and we're supposed to look out for pedestrians. Could have been a child, could have been anything, could have been anyone. And then to add insult to injury, this man was not supposed to be driving in the first place. His license was suspended. And had he not been driving, this particular accident would not have happened. So I'll grant it, and I don't even know if the man was drunk or not. But let's just say for sake of argument that he was. Makes no difference because their client did not yield the right of way to the pedestrian, even though the pedestrian was not crossing the street legally. It does not matter. That is not a superseding intervening act. As such, the court is satisfied that people have met their burden of probable cause as it relates to the charges contained in the point one. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this has been committed. The defendant will be bound over to Wayne County Third Circuit Court Criminal Division for proceedings. His arraignment on the information, date, and time will be November 2nd, 2023 at 9:00 a.m. The bond will be continued.
You all may step out, please. I would say first.
You'll make the facts. I know. That's what makes what you do artful.
We're down to 1:30.
Yes, we are.
Ms. Warner, you, when they call procurement?
I'll do it. Yeah, I'll do it. Lunch until 1:30, folks. I don't know if I got rid of inside. Mr. King was in trial.
Oh, that's the one, okay.
I think Mr. Drain is his office mate. Let me see if she can do this. Hey, Ms. Drain. Hi, Ms. Drain, can you hear me? So I was wondering, if Mr. King is coming to this trial. So I'm done. He'll be here for the exam. Beautiful. Okay, thank you so much. Appreciate it. So we got it in case it's gone to the jury, so
Okay.
we will be doing our 1:30.
Okay.
Me too.
Looks like a pencil right in
Mr. Schlaf.
there. Oh, okay.
You guys.
All right. right. Sorry, I just got next door to get water. We're down until 1:30. What's going on? We're down until 1:30. Yeah, I wish the case was gonna start earlier, because we finally get out before now. But come on. Yeah. Okay. Pringles? Yeah. Yeah, yeah. Yeah, it'll be a long time before dinner. Right. Yeah, I don't think, I got a text Michelle, I don't think Alex is gonna have it. We're seeing him on Sunday for dinner, but, he hasn't mentioned anything. Right, yeah. We've got a little bit issue with one of Andy's friends, and it's kind of bad situation, so nobody's really, I think Alex doesn't want to have a get together. You know what I mean? It's, I can't see. Yeah. Yeah, I'm gonna text her right now. Oh, that sounds good. Right. I'm gonna mention it. So I'm gonna say I was talking to Shelley. She mentioned ribs and pizza salad. And then I'll just ask her what she wants me to. I'll make some cookies or something. Okay. Yeah. Okay. Yeah. Okay. Yeah, I'm gonna show you the pans and you tell me what size pans you think we should do. And. Okay. Yeah. Yeah, I'll do a couple of those. Yeah. Right. Well, here's a thought too, is I thought about doing a couple of the egg bakes. And then what if we did some individual, quiches? I have so many recipes for little individual. No? Okay. Okay. Yeah. Okay. All right. Yeah. I would start getting those. I would start getting those because they don't always have them in stock. Yeah. Okay. I would get maybe 7 or 8, because not everybody will do cash box, I don't think they do. And then what, do you have room in your freezer? Okay. I've been doing it. Oh, you know what? Corey and Tim have that freezer in their garage. I always store stuff in there because they don't, she doesn't make, freeze a lot of stuff, so you can always put some in there. Yeah. I do too, but they'll give you, you take a ticket as you go in, and then they'll validate it when you check out at Trader Joe's, and then you just go out the other side and you scan your ticket and it lets you out. I know I don't like using that either, but I have done it. Yes, and then have them validate it when you check out. Yeah. Oh, nice. Do your shoes match? I never asked you about your shoes, how they match. Oh, good, good. Well, I just realized I have this navy silk jacket that I'm wearing, and I just realized that my old navy like dress shoes, the suede shoes, are old and uncomfortable. So yesterday I'm like, oh my gosh, I need to order navy suede shoes. So I had a hard time finding the ones I like, but I ordered them yesterday. I would have forgotten if they had no shoes. Yeah. Are you meeting with the planners tonight? Yes. Okay. Or I would rather have them really like fresher, because if I take them Tuesday, by Saturday, I'd rather, if you knew what time, ask me what time they're gonna. Oh, you're giving them the bags Friday, okay. Yeah. Okay, all right. Okay. 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 All right, then I'll have it done Tuesday. I'm home that week for Wyoming, which I'm glad. Okay. Okay, and I ordered these little tiny stickers to just close the bags, fold them over, close them. It just says made with love. It doesn't have any names or anything. Okay. Right. Okay. Yeah. Okay. All right. Yeah, I can do that. All right. Right. All right, yeah, I'll text her right now. All right, sounds good. Okay, all right, bye. Happy. Hi, how are you? I was kind of looking for but underneath this right here. It's not next door either. Yeah, they've been next to us for a couple hours. I almost told you that one.
Okay. You mean you're gonna stop me from walking over there?
Yes, actually, yeah. All right. No. Yeah. 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 She told me that. Okay. Oh, that's gonna cause really, she's gonna be pissed about that. She should have just extended the invite. I told her, she will not come. I go, you invite her? I know. Yeah. No, definitely not. I'm booking my flight this afternoon, these summer seats, but I'm coming back on this Sunday night because back Monday. That's my last week working physically of my job. So I'm coming home Sunday night on 7 p.m. flight. I get it at 10. Just gotta yeah. See, excited. What about jobs? And I said, also, you know, I want to work for that. Oh, yeah. Right. Yeah. And that's good for you too. Good combo. Right, exactly. It's, yeah. So it was Alex like, and just, yeah. Oh, I wish it would be. No. We just had a come. Right, well, just call me if you say when they're like, who's taking my shot? I have to talk to well, why do you give me a lot of time. So, Gally home tell. I know. I know. Okay.
Yeah.
Go outside, go outside,
Yes.
is it cold?
Well, it ain't really cold. It's like a chill, but then it started raining.
Oh, okay.
Yeah, so now it's.
When I looked outside, it looked so cold.
Yeah, it's cold, but it ain't like, one of them freezing, but it is cold. Okay. Okay.
Already on his way up.
As well.
Yeah, I called myself.
Oh, okay.
Well, you girl back. That's why I called Donnie and said, can you do my, what's going on? Well, okay. Wait a minute.
I checked it in.
And he said, you all right today, honey? It's Friday.
So,
Okay, well, can we act like it's Friday? You all right today, Madam Clerk?
yes, I am. You doing?
I'm wonderful. It's Friday. No,
You know.
I just say keep saying Friday every Monday.
This one in jail, right? This was.
Yeah, he's a jailer. I apologize. I thought I told you. Most of our homicide, been majority of homicide cases. How you doing today?
Good. Let me know when you get your
Did
paper.
you talk to your client?
Is he up here?
He's on his way up.
Let me just go to the men's room for a moment, I'll be back.
Okay, as long as you wash your hands with you. Don't let some. Take your time, sir. He's not going nowhere. Good afternoon. What's your name? Did you use the restroom while you was down there? You gotta go? Okay, come on.
Never see how smart you are. You know, but don't know if you got my message, but it's a false alarm.
Huh?
I said, I don't know whether you got my message, but it's a false alarm.
What's that?
Larry King might not be able to make it because of some problems with his trial, but it's all over with.
Yeah, he told me that, he sent me an email and a text stating that he has a jury out and they came back with the verdict.
Yeah.
He's taking the verdict, he'll be right over.
Yeah, just, I mean, I've seen the jail, just sure.
Come on. Your attorney's gonna come in and talk to you, go. And, just over there when, you done talking to him.
Okay.
Hello there, Dr. Watson.
Hopefully you can hear me, and thank you for accommodating my busted foot.
Okay, Sugarfoot, no problem.
The birds won't stay.
HLABATY. And Lee is spelled L-E-I-G-H, am I correct?
Yes.
That's from years of working with you. Mr. King, how are you, sir?
Be honest, I'm not doing so.
That verdict didn't come back like you thought it would.
It did not, but that's just part of it. I'm pretty much at my freaking wit's end.
Don't throw and break anything, okay?
I won't,
Have
but
that nickel in your face.
I might, I don't know, I might have to have,
You need a drink.
I need a break. I need a break. I can't go. Capital trial, here. I'm not a robot, I'm not a machine, I can't work like this. It's absolutely, utterly exhausting. Emotionally, physically draining. Madam Court Reporter, you need a copy of the medical examiner's report. Bear with us. Made a copy for you.
Oh, there you are. It's quiet.
Take a deep breath. Here, Your Honor. Want a couple of minutes? Want a couple of minutes? Take a deep breath.
Yeah, I'm gonna give the court a copy. I'd like to mark this one.
Go ahead, Nelson.
I'm gonna go out and check with my officer.
Okay.
My officer in charge is here. I know that 3 of the 5, 6 witnesses are here. Yeah.
Dr. Mack.
Yeah, I see Dr. Labios. You're okay with, I heard back from the court. I don't think I heard back from you. Yeah, but I asked you about it. The court said it was okay, but I didn't hear officially.
Officially, it's fine.
Let me go grab my officer in charge and give me a moment. I'll be right back.
Okay.
That's the second prosecutor today that said the same exact things. I saw the prosecutor this morning and I just saw him coming back.
I'm gonna come here with my gun.
Okay. Okay. Yeah.
I did come to talk. That's okay. It's just gonna take a long time.
But you know why they bother me? This didn't work.
Sir, that's okay.
All right.
Ready for Saturday?
Should I be ready for this one on seven? I know it's Swedish day,
A game.
but. Oh, no. No, not ready.
You know what's ready for you to work on?
No, you don't.
Let me get the digital, I can have a moment to get the digital file.
Is it a problem, sir? It's a problem?
No.
Okay. Okay, well, I'm getting to a point where you can say, yeah.
I just need a minute to get the
I
digital file.
understand, you want to, you have to be in the safe now. Okay.
So. got the voter first. I'd like to have I testified on purpose.
Would you carry with? I.
Almost, sorry. The second time there, he did set a lot more.
Yes.
All right, calling case 2359038. People of the state of Michigan versus Maurice Allison. Defendant is charged in count 1 homicide, murder, first degree premeditated. Defendant has a habitual offender for defense notice. Appearances for the record, please. Good afternoon, AJ. Larry King for the people, P78774.
Good afternoon, James Schlock, 30720. Yeah, Mr. Allison. We're ready for the preliminary exam. Move to sequester witnesses.
I would ask for exception for the officer in charge who's sitting to my right.
Objection.
All right, ladies and gentlemen out there in YouTube land, if you are a witness or potential witness, I'm going to log off this time. There doesn't appear to be any witnesses in the courtroom. We have approximately 3 to 6 witnesses, Mr. King. Approximately, I believe I have 6. I may be able to get away with 5. Okay. We have any preliminary matters you'd like to begin before we call witnesses? No, Judge. Okay. Well, I guess I do. I provided the court a copy of the medical examiner's report related to file 2311469. Dr. Lavey is present via Zoom with the court's permission to testify, but I would move for the admission of her report as a preliminary matter pursuant to court rules. Any objection?
Yes, for purposes of preliminary exam.
Yeah, I call Dr. Lee Lavey. Good afternoon again, Dr. Lavey. Can I get you to raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do.
Thank you very much. You may begin when you're ready. Ma'am, please state your full name for the record of the court.
My name is Dr. Lee Lavity.
You spell your last name so the reporter gets it correct in the record.
Yes, the last name is Hlavatty.
What do you do for a living now?
I am an assistant medical examiner employed at the Wayne County Medical Examiner's Office.
How long have you been employed in that capacity?
I've been at the office for 24 years. I started as an assistant. I did 11 years as deputy chief. And now that I am partially retired, I am back to assistant.
And you have any specialized training in the field of forensic pathology?
Yes.
Can you please briefly summarize that for the court?
Yes, after graduating medical school, I did my residency in anatomic pathology at the Detroit Medical Center. I did a fellowship in the field of forensic pathology at the Wayne County Medical Examiner's Office. And at the end of all that training, I became board certified in both anatomic and forensic pathology.
And have you previously testified in court as an expert witness?
Yes, I have.
In what field or fields?
In anatomic pathology and forensic pathology.
And approximately how many times have you been qualified as an expert?
Over 450.
At this time, I've moved to qualify Dr. Lavity as an expert in the field of forensic pathology.
Okay.
Okay. So we'll recognize Dr. Lavity as an expert in the field of anatomic and forensic pathology. So Dr. Lavity, are you familiar with the case that brings us to court today?
Yes, I am.
And in your employment with the Wayne County Medical Examiner's Office, did you have occasion to examine the body of a Miss Stacy Lynn Davis?
Yes, I performed an autopsy on her on September 18th of this year.
And what were your findings related to the autopsy?
The findings relating to autopsy were in several categories, if you would. There were findings that indicated that she had been strangled. There were also findings indicating other forms of asphyxiation, like smothering. She also had blunt force injuries to her face.
So let's just talk about the autopsy consists of an internal and external examination, correct?
Yes.
And when you were performing your external examination, did you note injuries on her neck, face, and head?
Yes.
Specifically, what injuries did you note?
Again, they were really in two categories. I'll start with the strangulation and asphyxiation. Her face was very congested, and there were pinpoint hemorrhages called petechia that were on her right eye and the tissue lining both eye sockets. There were small abrasions on the undersurface of her right chin or jaw. There were abrasions on the right side of her neck and a linear abrasion on the left side of her neck. Additionally, there were clusters of small, irregular and linear abrasions that were clustered on her right nostril and cheek, her right cheek and jawline, her left nostril and cheek, and her left cheek lateral to the mouth. And then finally, there were also injuries to the head relating to blunt force. And these were 2 bruises on the mid upper forehead. Both of the eyes were swollen and bruised. There was a laceration on the outer aspect of the right eyebrow. And then finally, there were injuries in the mouth. There was a laceration of the upper lip, bruising on the lower lip, and loss of 2 teeth.
So let's start with the findings related to strangulation. When you say congestion, what specifically do you mean? You mean like a cold, or is there a different meaning in this case?
The congestion means that the face is red or purple in color. When the blood flow is blocked to the head, it basically just accumulates, and the blood and the face and the skin will turn like a reddish purple color.
And when you talk about petechia, what in your expert opinion could cause such petechia?
Petechia in and on the eyes are caused by increase in pressure within the head. So in strangulation, the increased pressure of the blood not being able to drain ruptures the smallest blood vessels in the location of the eyes and the eye sockets.
And you had spoken about clusters of small linear abrasions. Are you able to opine whether those happened before or after death, or at the time of the death?
All of the injuries on her were recent. There were no post-mortem injuries present. So these, the clusters of abrasions, again, near her mouth, her cheeks, and on and around her nose, were all recent. The best that I can say is that they were inflicted within 24 hours of her death.
And did you observe any injuries on her that were in any stages of healing or did not appear recent?
No, she had numerous scars of different types on her body, but none of the injuries showed any evidence of healing.
And were you able to make a determination as to the cause of Miss Davis's death?
Yes, after I did the internal examination, I concluded that the cause of death was strangulation.
And what led you to that conclusion?
Internally, in the neck, there were hemorrhages in the strap muscles on both sides of the neck, specifically 2 on the left and 1 on the right. And with regards to other injuries, although she received blunt force impacts to the head, there were no internal head injuries present. So looking at this case in total, she died from strangulation.
And are you able to opine as to how much force would have to be applied to her neck in order to cause the injuries that you observed?
No, there is no way for us to know exactly how much force was used. It simply was enough force to block the blood from leaving and entering her head and cutting off oxygen to her brain cells. But there's no way for me to give you a pound force of that.
And would force have had to have been applied to both sides of the neck?
Yes.
And were you able to determine a manner of death?
The manner of death is homicide.
So were you able to determine how long Ms. Davis had been deceased prior to her coming to your medical examiner's office?
I can provide an estimate to the time of death because the determination of time of death is not an exact science. Based on the rigor mortis in the body and other postmortem changes, my best estimate would be that she was dead at around 24 hours. I say that based on the fact that rigor mortis starts to become evident and remains fully developed in the body for 16 to 24 hours in temperate climate. After that point, rigor mortis leaves and the changes of decomposition start. Miss Davis, rigor mortis had already passed, and although there were no external evidence of decomposition, her internal organs were starting to decompose. Thus, the estimate that the best estimate I could give for her time of death would be around 24 hours.
And so in your opinion, is it possible that she has been dead only a few hours?
No. The only scenario in which that would be possible is if the body was like at 95 or 100 degrees, because temperature can accelerate the appearance and disappearance of rigor mortis and the signs of decomposition. But barring an extreme temperature like that, no, she had to have been dead more than just a few hours for her internal organs to be as decomposed as they were.
Now, when you're talking about strangulation as a cause of death, is there a period of time over which the pressure to the neck has to be applied in order to cause death by strangulation?
Yes. Once constant pressure can be applied and maintained on the neck, meaning that the victim can no longer struggle and is overcome, they will lose consciousness within 30 seconds. The pressure then has to be continuously applied to the unconscious person for an additional 2 to 2.5 minutes, because that is how long the brain cells can last without receiving oxygen. So in total, 2.5 to 3 minutes of constant pressure on the neck will result in strangulation.
And in this case, would the blunt force trauma or any of your other findings have affected or shortened that period of time?
Yes, the blunt force impacts to the head, as well as the drugs that were in her system. These two insults to the body, although they did not contribute to her cause of death, they both would have shortened the amount of time it could have taken to strangle her.
So do you have an opinion as to a bare minimum amount of time that constant pressure would have had to have been applied to Miss Davis's neck in order to cause death by strangulation?
Well, again, there's no way to know the actual time unless the death was witnessed or recorded. However, the blunt force impacts did not have any internal findings. And the toxicology, I know that there was fentanyl in her liver tissue. She was decomposed to the point where we couldn't get blood. So I know that fentanyl was in her system, but I do not know what was in her blood at the time of her death, or how much had she used or when. So given that fact, they both would have shortened the time it would have taken to strangle her, but it wouldn't have been a matter of mere seconds. My best estimate, conservatively, based on my experience, would probably be halving the amount of time that it took her to strangle. So it would take at least a minute, minute and a half total, given the drugs in her liver and the impacts to her face.
Thank you, ma'am. I don't have any further questions.
Charles, is there? Just a few if I may. Good afternoon, ma'am.
Good afternoon.
So I'm interested in the time frame that you have posed in your testimony.
Okay.
Now, the body was recovered on September the 17th of 2023 at about 8:10 p.m. Are you aware of that?
Yes.
And when did you examine the body?
I examined her at 8 o'clock in the morning on the following morning, September 18th.
Okay. So it is your best belief, based on all these factors, that the person was dead for approximately 24 hours? Now, is that from 8 a.m. or is that from the time the body was recovered?
That would have been between the time the body was recovered and went into our cooler. When the body is received at our facility, it is refrigerated until it can be autopsied the following morning. And once the refrigeration is applied, all of the changes cease. So the changes I saw would have been the changes that she had late in the evening of the 17th when she entered our facility.
All right. So the date of death could have been as early as September the 16th. Is that your testimony?
Yes. Yes.
And of course, you can't give an exact time, but you're saying about 24 hours.
Correct. Given the degree of the internal decomposition of the organs, yes.
All right, so now you've noticed a number of injuries to the body. That was your testimony, is that correct?
Yes.
Including strangulation as well.
Yes.
Now, as part of your duties of doing a medical, an examination, forensic examination, you consult with the police beforehand?
Sometimes the police are present and provide us information. However, I only seek out the information that would be pertinent to the cause of death and the manner of death.
On this occasion, did you have access to either police officers or the actual police reports?
I did not have access to the police reports. I have the report of the officer who reported the death to our office, which was Officer Riviera. And then later, the day of autopsy and the following day, the officer in charge of the case, as well as the prosecutor seated at the table, had contacted me in order to have the injuries explained to them.
So as part of your medical examination, or I should say your forensic examination, are there times when you're instructed to try to recover DNA?
With regards to, I guess, two questions. One is we will only recover DNA specimens if requested, but certainly when decomposition starts, the probability of getting useful DNA goes down significantly. In this case, nothing but fingernails were requested, so that was the only evidence that was taken.
When you're saying fingernails, are you speaking of the deceased fingernails?
Yes, the fingernails were clipped.
And were they clipped, or to your knowledge, were they actually scraped and that evidence recovered as well?
Oh, no, we clip the fingernails, and so the tops of the fingernails and any material that would be with them is what we submit in the envelope, excuse me.
So based on the period of time that elapsed, you didn't try to recover any skin DNA from anybody who might have choked that person?
No.
Or any other liquids, or I should say, from another person?
No, that is not part of my responsibility. We perform autopsies and we will recover evidence from the deceased. Any evidence on living people involved in a case would be done by the police.
To your knowledge, did the police try to do anything to recover that type of evidence in this case?
I have no idea.
She could answer yes or no.
How would she know?
She's
not a police officer.
I don't have any knowledge.
It sounds like she doesn't have any knowledge. So, you also testified to the toxology in this case.
Yes.
And you seem to believe that there was a significant amount of fentanyl?
In her liver tissue, which is not what was in her blood at the time of her death.
And besides the liver tissue, is there any way to know the amount of fentanyl in a body?
No. When decomposition starts, the blood breaks down in the blood vessels, so there's no more liquid specimens to be collected. So in people who are decomposing, we submit liver because that's the solid organ that the majority of reference toxicology data has been done. So in decomposed people with liver values, we know that it's in their system, but we don't know when they last used or what was the level that was in their blood.
Was there any other toxicology information that's significant in this case?
Well, there were a total of 4 substances that were found in her liver. 2 were only screened, so they were not quantitated, and that was acetaminophen and caffeine. And then a breakdown product of fentanyl was also in her system, and that breakdown product is called norfentanyl.
Is there anything about the examination of the body which might make you believe that there was more than one person who participated in the death of this Ms. Davis?
Honestly, I don't know who the assailant or assailants are, so I cannot answer that question.
I understand you don't know the identity, but nothing that would show multiple people.
These injuries could have been created by one person. They could have been created by more than one person. I have no way of knowing.
All right. All right, nothing further.
Any redirect?
No, Judge, thank you.
All right. Thank you, doctor. Appreciate your time.
Thank you so much. Bye.
Call Officer Garrett next.
Sir, please give your name and spelling to the court reporter. Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. Please have a seat. The witness box next to me. Just yank it over. You may begin when you're ready.
Sir, could you please state your full name for the record and spell your last name?
Yes, sir. My name is Juan Rivera, R-I-V-E-R.
And what do you do for a living, sir?
I'm a police officer for a Detroit Police Department.
How long have you been employed as a police officer?
1 month, sir.
Were you working September the 17th of 2023?
Yes, sir.
And on that day, what shift were you?
2 to 3 afternoons,
And that's when to when?
from 4 to 12.
On that date, did there come a time when you were dispatched to 14141 Hempt, P-F-E-N-T Street? Fent, P-F-E-N-T Street, apartment 17, Detroit, Michigan, 48205.
Yes, sir.
And that is within Wayne County, Detroit, Wayne County, correct?
Yes, sir.
What was the nature of the call that brought you to that scene?
A death on scene, sir.
Okay.
Death on scene?
Death on scene?
Yes, sir.
How about what time did you arrive at that location?
From I will look at the report, sir.
So would a review of your report refresh your recollection as to the time that you arrived on the scene?
Yes, sir.
And you have a copy of your report with you?
Yes, sir.
I mean, this officer refresh his recollection using his report?
Yes. No objection.
Can that refresh your recollection, sir?
Yes, sir.
So about what time did you arrive?
2058.
And were there any other officers present with you or when you arrived?
Yes, sir.
With you or when you arrived?
With
Who was with you?
Officer Melendez.
So when you arrived at the scene, this is an apartment, correct?
Yes, sir.
And do you need to go inside a building to access the apartment or is it outside?
There's an outside door to get access into the apartment, sir.
And what happened when you arrived?
Well, when we arrived, we made our way to the apartment. We opened the door and saw that the victim was laying in the bed.
Was there anyone else present?
The suspect, sir, in another room.
I'm sorry, I didn't get the end of that.
The suspect in another room.
So you just walked out into the apartment or did you knock and somebody answer? How did that go?
The apartment had a screen, mosquito like cover. The door was open and we entered.
Where in the apartment did you observe the deceased?
In the living room.
And was she immediately visible when you arrived?
Yes, sir.
And how was this person positioned?
laid face up, laid face on the ground. Face up.
And was there anything near her?
Yes, I observed there was pill bottles on the side.
And did you observe any injuries on her?
Yes, I could see she had 2 black eyes. So
And did you observe any other injuries?
I observed that she had trauma on the top of her head.
Now, did you make contact with anybody else inside of the apartment?
Just a suspect.
And where was this person located?
A bedroom.
And the suspect, do you see him here in court?
Yes, sir.
You identify him by where he's seated and what he's wearing.
Yes, sir. You're left side wearing green shirt.
And did you ask this person anything about what had happened?
Yes, I asked him, when was the last time she seen it? And further information on who she was.
And were you able to identify the deceased?
Yes, sir, there was identification.
And what was the identity of the deceased? May this witness refresh, I would ask this witness to be able to refresh his recollection using his report. No objections. Okay. What was the identity of the deceased?
Basically, the name, sir.
Did the defendant explain to you when he had last seen her?
Yes, very vaguely, sir. 3 or 4 hours ago, previous to us.
Was anyone else called to the scene?
Yes, sir.
Who else was called?
To the microphone for me, sir.
Who else was called to the scene, sir?
The homicide detective, sir.
And was the defendant arrested when you spoke with him?
No, sir.
Nothing further.
Cross-examine.
Tell me the day or night that you arrived at the apartment.
The night of December 17th, sir.
When you say the night, was there a particular time?
Yes, sir. 8:58, sir.
You know, okay. And you were with another officer or multiple officers?
Yes, my partner, Officer Melendez.
All right, and you both entered the apartment house?
Yes, sir.
You went directly to that apartment?
Yes, sir.
Did you have to go upstairs or was it on the first level?
Upstairs, sir.
All right, how many flights? 1, 2, 3?
1.
One flight upstairs? Did anything seem to be wrong on the flight upstairs?
On the flight upstairs, no, sir.
Okay, the doorway?
The doorway.
When you got to the apartment, was the door already open?
Yes, sir.
Okay, did you go in?
Yes.
Did you announce yourself and your presence?
Yes, sir.
Okay, and you're saying that my client, Mr. Allison, came out from the bedroom?
No, he never left the bedroom.
Never left the bedroom. And you entered the apartment. Did you immediately go towards the other rooms in the house?
Yes, sir.
And you discovered him in the bedroom?
Yes.
You questioned him or did some other officer?
The officer questioned at first, and I questioned him.
All right. But there was nothing else except as to what you stated today.
No, sir.
How long did it take for other officers to arrive?
Up to an hour, sir.
And an ambulance?
The ambulance was there first, sir.
Sorry,
The ambulance was already there, sir.
the ambulance was there before you arrived?
Yes, sir.
So there were medical technicians there as well?
There were.
How many medical technicians?
From,
Did you remember?
I don't recall, sir.
Were they doing anything in relationship to this date?
From what they told me, they attempted.
After that, did you go to the scene?
Yes, sir.
And other officers arrived?
Yes.
All right, nothing further.
Can you redirect? No, Judge, thank you. Thank you, sir. You must have. Can I call Sergeant Stephen Hyde? Sir, please give your name and spelling to the court report.
Yes, Your Honor. Sergeant Stephen Hyde, STEVENHENHEID.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do swear.
Thank you, sir. Please have a seat with witness box. You may begin when you're ready.
Just get your full name for the record of the court, spell your last name.
Yeah, Sergeant Stephen Hyde, spelled HEID.
What do you do for a living, sir?
I am the supervisor of the Eastern Squad, Detroit Police Department's homicide section.
Sir, are you familiar with the case that brings us to court?
I am.
And on September the 17th of 23, did you make it to the location at 14141 Fench Street, apartment 17?
I did.
About what time did you arrive?
I don't remember.
Was it?
It was in the evening.
Was it dark outside?
It was, yes.
And were other units on the scene when you arrived?
Yes, there were.
What was the reason for you being called to the scene, sir?
I was notified of a possibly suspicious death.
And when you arrived on the scene, did you enter the dwelling?
I did.
And did you observe the deceased?
Yes, I did.
And how many homicide crime scenes have you been out to in your career?
I would say probably around 15 to 20.
And did anything immediately stand out to you about this particular deceased?
There was definitely some bruising on the decedent's face.
And did you observe anything else about her?
As far as
Just anything else?
no.
I'm very sorry, I did not know that was gonna do that. Do you recall what the temperature was like in the apartment when you arrived?
I do not.
Was anyone else present in the apartment when you arrived as far as civilians?
Yes.
Who?
Mr. Maurice Allison.
And where was Mr. Maurice Allison?
When I made contact with Mr. Allison, he was in his bedroom.
And what was the purpose for you making contact with Mr. Allison?
I was informed that he was the 911 caller and he was the other occupant inside the apartment.
And did you have a chance to speak with Mr. Allison?
I did.
And when you spoke with him, did this take place in his bedroom?
No, it did not.
Where did it take place?
In my vehicle.
And was he under arrest at the time?
No, he was not.
Was he in cuffs?
No, he was not.
Was he free to leave when you spoke, as you spoke?
Yes, he was.
When you spoke with him, did he inform you of the circumstances which caused him to call? Did he inform you of the circumstances which caused him to call?
Yes, he did.
What specifically did he tell you?
Mr. Allison said he returned home and found his girlfriend unresponsive on the ground. He attempted to revive her. When those attempts were unsuccessful, he called 911 with her phone.
And did he explain to you where he had been previously, what he had done previously?
Yes, he did.
What did he say?
He had stated that he was going to attend the movies at 14 and Gratiot. However, the bus was not coming fast enough. He had told me a few other stops. I believe he said he stopped at the CVS to inquire about some fly traps. And he also told me that he went into the Dunkin' Donuts and purchased the donut.
And did he provide you a time frame for the last time that he had seen this, the decedent alive?
At the time that interview, yes.
What did he say?
He said it was approximately a half an hour to an hour before he left I'm sorry. He had been out for about an hour or so, and that's when he returned home and found the decedent.
And he informed you that she was alive in the home when he left approximately an hour prior?
At the time of that interview, yes.
Just one second, if I could. And did he inform you whether or not anyone else was present in the apartment at any point in time?
That would have been in a subsequent.
When did you interview him again?
I believe it was a day or two after the original scene.
So was he actually arrested and taken into custody on this day on the 17th?
No, he was not.
But you later returned to the apartment, is that correct?
That is correct.
And when you spoke with him again, was he in custody at that time?
The second time I spoke to him?
Yeah.
Yes, he was.
So I don't have anything further. Thank you.
Cross-examine.
Please. Good afternoon, officer, detective, what is it these days?
It's Sergeant.
Sergeant.
Good afternoon.
So, you responded to the apartment, is that correct?
Yeah, the original date, yes.
Oh. And, you recall what time that you left?
I don't recall the exact time. I want to say it was late evening going into the early morning.
Late evening, 11, 12 o'clock?
I believe so, if I'm not mistaken.
Okay. And, when you got there, there were still other officers there, is that correct?
That is correct.
And, Mr. Allison was there as well?
That is correct.
So, you first met him, he was in the bedroom, is that correct?
That is correct.
Were there any officers with him in the bedroom?
The time I made contact, no.
So, your testimony is somehow he got from the bedroom to your squad. Say yes.
I'm sorry, yes.
How did that happen?
I asked him if he would come speak to me.
Did that find any came to you voluntarily?
Yes, he did.
And you're saying he was not under arrest?
That is correct.
He was free to deny you?
That is correct.
And why did you want to speak to him in your squad?
Because he was the original 911 caller, and he had stated to, yes, the 911 call was that his girlfriend was unresponsive, so I was trying to obtain details about the incident.
Is it because you wanted to record him?
Because I wanted to what?
Record him? Is that why he was in the squad car?
No, I like to make sure that nobody's around when I'm doing the interrogation. He was being recorded, yes.
And you're saying that he could have left any time during that interrogation?
That's correct. He was not in custody.
And you did not give him his right to. Yeah.
No, he didn't. No, I didn't.
Did he ask for a lawyer?
No, I do not believe he did.
You don't believe he did, or do you know?
Not that I can recall.
Right. And well, did you preface your conversation with him in any way, or you just started in on questions?
I just asked him what had happened, why I was there.
All right. And how long did this interview take?
I believe probably around 15 to 20 minutes.
Right. Were you the only one present during this interview?
I was.
Where were the other officers still in the apartment?
That is correct.
Was he in the back seat?
No, he was not.
Front seat with you?
Yes.
Did he appear to be sober?
I don't recall having any indication that he was intoxicated.
Did you smell any alcohol?
No, I did not.
Anything about his manner that would make you think that he was intoxicated in some way?
He was extremely distraught as far as intoxication. I don't remember.
How do you mean distraught?
He was very upset.
Was he upset from the beginning of your, when you first saw him?
Yes, he was.
That was through your interview?
That is correct.
I just saw crying, things along those lines.
That is correct.
So you said there was a time that he made a second statement.
That is correct.
Were you the person who interviewed him on that second statement?
I was one of the people. Yes.
One of the, okay. And was he under arrest at that time?
Yes, he was.
And when was he placed under arrest?
He would have been arrested that day.
That day meaning what?
I believe, if I'm not mistaken, it was, I believe, September 19th.
My birthday?
Maybe.
So when he was arrested, did you come out to the house?
That is correct.
You personally?
Yes.
Placed him under arrest?
Well, I did not place handcuffs on him. Our special response team, our SWAT team, was the one who took him into custody, but I was at the location at the time.
Was there any conversation with him prior to the interview at the station or the Detroit detention center?
I spoke with him briefly in the backseat, let him know that I would be speaking to him when we returned back to.
Anything of substance to that conversation?
No.
Any promises?
No.
Did he ask for a lawyer at that time?
No, he didn't.
I'm sorry, Judge. I'm just trying to find out the date. Okay. All right, I just wanted to. No.
You redirect? No, Judge. Thank you, sir.
Thank you, Your Honor.
Can I have just a moment, Judge? Teresa Davis. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Please have a seat in the witness box right next to me. Keep your voice up nice and loud and speaking to that microphone that we do with us, okay? Just yank it away. Thank you. You may begin when you're ready. Ma'am, could you please state your full name for the record of the court?
Doretha Davis.
Ms. Davis, what is your relationship to Stacy Davis?
That's my daughter.
Have you known her your whole life?
Yes.
And how old was she prior to her death?
33.
Do you know Mr. Maurice Allison?
No, I do not.
Do you know of Mr. Maurice Allison?
Just to the fact that he was her boyfriend.
And you know how long she had been dating?
Off and on about 2 years.
Did she live with him prior to her death?
Yes.
And do you know where she lived?
The student spent
Okay,
in an apartment building.
And was, aside from her and Miss Davis, Mr. Allison, did anyone else live in that apartment?
Oh, there was a whole bunch of people that lived in the building. I don't know about their apartment. 'Cause
That particular apartment though?
I don't know.
And I wanted to talk about during the course of the relationship, did your daughter ever talk to you about Mr. Allison?
No.
Did you ever observe your daughter to have any injuries on her?
Yes.
Did you observe your daughter to have these injuries before or during the relationship with Mr. Allison?
During the relationship.
I'm going to object, Your Honor. I don't see the relevance to it at this time. Well, she doesn't seem to know the source of them. She doesn't seem to know the source of the injuries, how they were inflicted or anything like that. So yeah, I don't think it's relevant.
Sounds like we're trying to put forth some circumstantial.
I think there has to be a better foundation.
So, Your Honor, I would say that between these next two witnesses, this is going to be other acts of domestic violence evidence pursuant to MCL 768.27B, which is admissible for various purposes of group propensity.
Your Honor.
Notice of that?
No, you do not have to give notice. It only has to be disclosed to the defense. And it only has to be 15 days prior to trial. The statement of this witness and the plaintiff's sister are both included in the discovery, which is provided to the defense.
Mr. Swell?
That still doesn't give a proper foundation for who may have inflicted these injuries.
That would be for the trial.
Well, this court is the fact finder for this type of hearing.
Oh, the objections made. May proceed.
So just to be clear, prior to your daughter beginning a relationship with Mr. Allison, you did not see injuries.
No,
But once she began the relationship, did you begin to see injuries on your daughter?
yes,
What type of injuries did you begin to see on your daughter as this relationship?
bruises and cuts on her neck.
There come a time, like in 2022, when you took your daughter to the hospital.
Yes,
What hospital?
Ross,
And why?
because she couldn't walk.
Do you know what type of, were you with her when she met with the doctors?
No,
Did you speak with her about her medical care?
no,
When you said she couldn't walk, what type of injuries did you observe?
she was limping and she had feet print on her back of her heels, on the back of her thighs. And her calves.
Just one second. After this incident, did she continue to reside with Mr. Allison?
Yes,
Did you ever?
I mean, she doesn't seem to have any personal knowledge of who her daughter was living with. Never met the person who never was over here.
You knew where your daughter lived?
I knew good where the building was.
And did you know who she lived with?
No, she never disclosed her name or nothing.
Just one second. I'm gonna rest with this witness at this time, Judge. I'm gonna call a different witness after the defense is crossed.
None.
Thank you, ma'am. You may step in.
So I'm gonna call this Miss Jenny Davis, if I could.
Ma'am, please step forward, give your name and spelling to the young lady seated over here. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Thank you. Please have a seat. The witness box right next to you. Voice up nice and loud, speak to that microphone to your left, okay? You may begin when you're ready.
Ma'am, please state your name for the record one more time.
Jenny Davis,
Ms. Davis, how do you know the decedent, Ms. Stacy Davis?
that's my sister,
You've known her your whole life?
my whole life. I'm 41 and she's 33.
Your little sister?
That's my baby sister.
Did you know where your sister was living before she died?
Yes, I did.
Have you been there?
Yeah, no, not until after.
She had told you about where she was living?
Yes,
And you did visit this location afterwards?
yes,
And you retrieved some personal belongings of hers from this location?
yes.
And where was that?
In the closet.
Where was she living?
She was living at 14144 Bench Street.
Was that an apartment?
Yes, and
And
it was apartment 18.
did you know, from your communications with your sister or any other way, who she was dating?
Yes, I had met him.
When did you meet him?
It was on his birthday 2 years ago.
And how did you come to meet this person?
She brought him to my house.
And how did she introduce him?
She introduced me as her boyfriend to me. He was her boyfriend at the
And
time.
do you know the identity of that person?
You said what?
Who was he?
He was her boyfriend.
Well, what was his name?
His name was Maurice Allison.
And do you see him here?
Yes, I do.
Where's he seated? What's he wearing?
Sitting right there in the green.
Record reflect identification of the defendant?
So,
Now, during the time that your sister was dating Mr. Allison, did you continue to communicate with her?
Every day.
And did you see her on a regular basis?
No, because he kept her away from us.
Objection. She's beyond her knowledge. Speculation.
how do you know you kept her away?
Because originally, before they was in a relationship, she used to call me every day, or she would be at my house. When they got together, he moved her out of my house and moved her in there with him. And then our communication started becoming every day to every other day to once a week to once a month.
How do you know that's,
Because she would try to keep things away from me, knowing that how I would react.
Thank you. So, during the time that your sister was dating Mr. Allison, did she ever speak to you about him?
Yeah,
And did you ever observe her to have any injuries?
a lot of them.
When did you first start noticing those injuries?
Okay, so when she had moved out my house, she had came back one time prior to this situation happening, and she had came to the house and she was washing clothes. That's when me and her had sat down and we had a conversation, and she had 2 black eyes at that time.
And when was that?
It was a year after they'd been together.
And did you observe any injuries on her at any other time?
Yes, because last year in September, she came to my house. She barely could walk. And that's when he had jumped on her and she explained to me then.
She wasn't present to know when who gave her these injuries.
I'm gonna get there. So she could barely walk?
She could barely walk. She couldn't do, and when I had to force her to go to the hospital.
So how did she appear besides the inability to walk?
She had bruises on her face from the 2 black eyes. She had 2 black eyes at the time. And then she had a bruise on her shoulder.
And did you speak with her without saying what she said? Did you speak?
Yes, I spoke with my sister.
And how was she acting when you were speaking with her?
She was crying. She was in tears. She seemed like she wasn't done, if that makes any sense.
And when she was in tears crying, did she have occasion to explain to you the source of her injuries?
Yes.
So at this point, Judge, she's visibly injured. She's coming to her sister. She's in tears crying about this incident. I think I would posit to the court that I've established basis for an excited utterance, and I'd like to continue the question. How's that?
Nothing exciting if the injuries happened quite some time before. We don't know that.
But if she's crying, it indicates that she's still under stress of what can take place.
That's my position, Chief.
It's not my position, though. She may have been emotional on telling this witness what happened, but she's not emotional because she had just suffered the injuries. She's not under that feelings, those anguish.
When did you last see her before you noticed her with the injuries?
Okay, the last time I physically laid my eyes on my sister,
Before you saw the injuries?
before I saw the injuries, was 3 weeks prior to me seeing her with them injuries. 'Cause she showed up at my house, and on September I think it was the 3rd or the 5th of last year. It was Labor Day weekend. She came to my house, her and my cousin showed up at my house. They showed up at the same time. Like I said, Stacy couldn't walk. I had to force her the next day to go to the hospital because she couldn't walk.
Did she indicate to you how and when she received those injuries?
Yes, he jumped on her.
Did she say when?
He jumped on her and he put her out
Did she say when?
the same day. He
The
jumped on
same
her.
day that you saw her? That she
Exactly,
came
the
over?
same day that she came over to my house. He said they just got into a fight and he jumped on her and put her out.
How long has been started to?
So when we're talking about this he that had jumped on her and put her out, who is that?
Mr. Allison.
And did she say anything else to you about what?
She didn't really want to get into all of that because, like I said, she knew how I would react. And that's why she tried to keep a lot of things away from me. But like I said, the bruises, she couldn't keep away from me.
Did you encourage her to talk to the police?
I tried, but when a person gets in somebody's ear, that's impossible.
So you tried to get her to talk to the police?
Yes, I did, plenty of times.
Did she tell you why she did not talk?
Because she was in love with him. And he keep telling her he loved her.
Nothing further.
Cross examine? No cross. Thank you, ma'am. You missed it.
Okay.
They called Sergeant Todd Eby. And I need to actually grab it myself because I got blue shirts next. See how here? All right, got it. Sorry about that, Judge.
Raise your hand, you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Thank you, sir. Please understand your response. May begin when you're ready.
So could you please state your full name for the record of the court?
My name is Todd Eby.
And how, what do you do for a living, sir?
I'm employed by the Detroit Police Department.
In what capacity?
I am a sergeant and I'm assigned to homicide.
And during your employment, did you have occasion to meet with the defendant in this case, Mr. Maurice Allison?
I did.
When did that meeting take
I
place?
believe it was on September 19th, if I remember correctly.
If the report says the 20th, would you have a reason to dispute that?
I would not dispute that.
And that is of this year?
That is
Where did that meeting take place?
Detroit Police Headquarters, 5th floor in an interview room.
And while you were in this interview, did you inform him of his constitutional rights?
I did.
Did you inform him that he had the right to remain silent and not answer any questions?
I did.
And did you inform him that he had the right to have an attorney present if he wished?
I did.
Did you actually have a form that lists out his constitutional rights?
I did.
And did you go over each one of those rights with him?
I did.
And did he express to you that he understood those rights?
He did.
Did he appear to be intoxicated or under the influence?
He did not.
Did he give you any indication that he did not understand his rights?
He did not.
Did he indicate to you? Did he indicate to you that he understood the rights that you put forward to him?
He did.
And what was the purpose of you speaking with Mr. Allison?
I was conducting a pre-interview in respect to a specialized skill that I have for training.
And when you were speaking with him, did you speak with him about the death of Miss Stacy Lynn Davis?
I did.
And did he tell you what had occurred leading up to her death?
He gave me a statement, yes.
What specifically did you say?
And I'm gonna have to paraphrase, because it was kind of a lengthy conversation. He indicated that, he was celebrating his birthday and that he had left the apartment, and when he returned, he discovered her body in the living room or close to the front door. She was unresponsive, and that was basically Clifton's version of our conversation.
Did you confront him about any inconsistencies in his statement?
No, by design.
Just 1 second. Just a second, Judge. I need a minute with my officer in charge. Can you recess for just a moment, please? Okay. Thank you.
There's some drama at the end of that. It's okay.
Thank you.
Give me 1 minute.
He has to go to the bathroom, yeah.
Okay. Okay, Judge, sorry about that. I have a couple more questions with this, and then I'm gonna need to recall.
Client went to the restroom.
In the restroom. No.
Then we are back on the record on Peter versus Maurice Allison. Okay. Okay. So Surgeon Evie, you said you had a specialized skill, correct?
Specialized training.
Great. And did you spend some time speaking with Mr. Allison?
I did.
And after that was concluded, what happened?
I conducted a second interview, partially in the presence of Sergeant Hyde. I had left that interview after probably 10 or 15 minutes because I had another appointment.
And then you said there was a follow-up interview with you and Sergeant Hyde?
Yeah, so initially, I conducted an interview, and it was just the defendant and myself.
Correct.
Shortly after, maybe an hour and a half after, the defendant was still in my presence, he had never left. I conducted a second interview, and that was in the presence of Sergeant Hyde. He had joined me for that second interview, which was probably an hour or two after the initial.
And was this kind of all one continuous transaction after you had read the Miranda rights to the defendant?
Oh, absolutely, yeah.
And did he say anything different during that second interview?
I was only there partially.
So was that interview actually conducted by Sergeant Hyde then?
Yes, but I was present for a very small portion of it.
What do you recall from the portion that you were present?
I recall the defendant continuing to deny any involvement in the murder.
So, Your Honor, once this cross-examination is clear,
leave to recall. I don't know if it's present.
Okay,
Yes,
so just to understand, you conducted an interview with him alone, is that correct?
Correct.
And was he under arrest at that time?
Yes, he was brought over from the Detroit Detention Center.
And did you personally take him from the cell and bring him into the interview room?
I did not.
So during your interview, your sole interview, you did inform of this right, is that correct?
I did.
And before you informed him of his rights, was there any conversation between you two?
No, maybe getting some biographical information, but in terms of a question and answer format type of interview, that was all conducted after the Miranda warnings were provided.
Well, still sticking to this, prior interview, a formal interview, was there any request for an attorney from that client?
There was not.
Any reluctance on his part or any refusal to be interviewed?
There was not. He endorsed the constitutional rights. He said he understood them, and he agreed to waive them.
So you went through an interview process with him.
He did.
And at some point that ended, correct?
No, I would disagree with that. I would
Okay,
say
why?
that at some point Sergeant Hyde joined.
So you're the one who said there was 2 interviews, though.
One without the presence of Sergeant Hyde, and then at some point Sergeant Hyde had joined me.
Okay, so before Sergeant Hyde came in, was there a period of silence where there was no interview going on?
Yes, when I did consult, when I had left the room to consult with Sergeant Hyde.
How long did that period of silence go on?
I don't count it. I couldn't even tell you.
Is this your way of telling us that there was no second Miranda rights given to my client?
Yes.
So when Sergeant Hyde came in, he just started questioning, is that correct?
No, I had led the questioning.
Okay, did he join in at any point?
He did.
How long did the first interview go on? Your sole interview.
Maybe an hour.
How long did the second interview go on?
I don't know because I left.
Okay. How long did it go on before you left?
My guess is 15 or 20 minutes, and then I had to leave.
No, Your Honor, I would recall Sergeant Hyde at this time. Sir. Do we need to re-swear him, or is he still under oath?
swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thanks. Thanks. Then when you're ready.
So, sir, are you familiar with the interview that was conducted by Sergeant Todd Eby on the defendant September 20th at EBD headquarters?
Yes.
And was there a time during this interview where Sergeant Eby left the room and consulted with you?
Yes.
And then at that point in time, did both of you continue speaking with Mr. Allison?
Yes.
And were you aware that Mr. Allison had been read his rights by Sergeant Eby?
Yes.
And at any point in time, did he get put back into holding or leave the interview room?
I believe he was the room next door.
So it was just moved from one room to the room next door?
That's correct, yes.
How long was Sergeant Eby consulting with you after his initial interview before you joined?
Are you talking about when I spoke to Mr. Allison?
Evie talks to Mr. Allison. Evie comes out, Evie has a conversation with you, and the two of you speak with Mr. Allison again, correct? And then Evie leaves while you're talking.
So Mr. Allison had conveyed to me that he was hungry, so I went and got him a wrap. I allowed him a few moments to eat that, and then I re-entered the interview room with Sergeant.
So how long was this little lunch break?
I would say probably 20 to 30 minutes.
When you re-entered the interview room with Sergeant Evie, did one of you continue to question Mr. X?
Yes.
And did there come a time when Sergeant Evie left the room to go to another appointment?
Yes.
And did you continue to question Mr. Allison?
Yes.
And during this continued questioning of Mr. Allison, did he say anything to you?
Yes.
Okay. What did he say to you, sir?
I had Mr. Allison go through the events of the day. Actually, I had Mr. Allison go through the events of the previous couple days before that I had met him. So we went through those events again. And then at that point, Mr. Allison gave several different accounts of what was going on. And then the final account being that Ms. Davis had returned home on the night of September 16th. They had gotten into an argument about her coming home too early. He thought it was a red flag. Mr. Allison admitted to me that he, quote, smacked the fuck out of her.
Stop it. Okay. And did he say anything else to you related to her death?
He stated he understood now. He didn't know that she was dead, but he was going to take responsibility.
Councilman Zach?
Sergeant Evie was conducting his sole interview. Were you doing that in any way?
Yes, I was.
So you saw the whole of his interview?
There were times where I got up, but yes, I watched the majority of the video.
And to your recollection, how long was his sole interview?
I don't know.
An hour, better than an hour?
It would probably be close to an hour and a half to 2 hours.
So 2 hours, hour and a half to 2 hours.
Yes.
And was there any break, or did you come in at a short time after?
A break
Between the first interview and the second?
Like I said, Mr. Allison had relayed to me he was hungry, so that I provided him with food. I gave him some time to eat that food, and so like I said, between 20 and 30 minutes between the first interview with Sergeant Evie and the time that I came in.
But you didn't renew, tell him again his Miranda rights and things like that?
No, I did not.
And did he ask or invoke any of his rights?
No, he did not.
Okay. And so he gave you a version that there's an argument between the two of them.
That's correct.
And in his words, or the words that you quoted, he slapped the fuck out of her?
That's what he told me, yes.
And took responsibility for that? Is that how you took his meaning?
Took responsibility for her death. That's the meaning I took out of his words.
But he didn't say he killed her.
He said he didn't know that she was dead, but he could see it how I saw it, and that he was going to take responsibility for this.
So he believed, according to what you're telling us, that you believed that he thought that you believed that he killed her. Is that what he said to you?
I'm confused by that question.
Okay. I guess the way you quoted was that he thought that you believed that he killed her. Is that a mischaracterization?
I think, Judge, first of all, I would object to kind of the form of the question. It's rather difficult to follow. And if I'm understanding the question correctly, it's calling for this officer to speculate as to what Mr. Allison thought. And maybe I misunderstood.
No, I'm asking what the words were. What his words to the officer?
Charlie.
He claimed to have slapped the fuck out of her in his words, is that correct?
That is correct.
He never said definitively that he killed her, did he?
No, I don't believe so.
He believed that was your position.
That's not how I took it.
Well, then tell me.
You're asking him to tell what he believes. That's
Tell me
what
his, I'm sorry, Judge, I don't want to cut you. Tell me his words again.
On which part?
The words that you're, to the part where you're, tell me the whole phrasing of his words you have.
So I mean, it was a lengthy interview, so the slapping the fuck out of her quote and the fact that he took responsibility were not right after one another. As in regards to, when he stated she walked in, there was an argument about there being a red flag that she was home so early. He had made the quote to me, "I slapped the fuck out of her." I asked him about how many times he hit her, he said twice. At that, there was more conversation, I would have to watch the video, but then at one point in the interview, he basically stated, because I told him that he would have to explain to a jury of his peers what his thought process was that night, and he had told me that this wasn't going to a jury, that he was going to take responsibility. And he said, I didn't know that she was dead in regards to when he came back, because I had challenged Mr. Allison on the fact that I believe that he knew prior to him calling 911 that she was dead. He stated, no, when I came in the apartment, that's when I found out that she was dead. And then I realized that I'm gonna take responsibility for that.
So you're stating that he came into the apartment, he knew she was dead, and he's taking responsibility for it? Are those your words?
Those are the words that he had stated to me.
And that's what you're repeating in court?
Yes.
That he came into the apartment, saw that she was dead, and was taking responsibility?
Yes, those were things that he told me in the interview. Yes.
And he also said he hit her twice?
Yes.
He gave no other details?
I mean, in regards to details to what?
As to any assault?
No, he said that all he did was hit her twice.
Thank you.
Anything else?
But I just want to be clear, the quote, "smack the fuck out of her" quote was his words, correct?
Yes.
Thank you, sir.
Thank you.
No further witnesses, Judge.
Any witnesses for the defendant?
No.
People?
People move for bind over on all counts. It's very clear that the decedent was dead in the apartment for quite some time. There is an apparent history of violence between these two people, which is not to be taken without consideration. But they were alone in the apartment, they lived there together. The story that the defendant tells about just finding her dead does not hold water, especially in light of the fact that she had actually begun to decompose, as stated by the doctor. And once confronted eventually with his inconsistencies, he admitted a portion of the truth, that being that when she returned home on the 16th, they got into an argument and he, quote, smacked the fuck out of her. He admits to beating her, and the cause of death was manual strangulation. There's probable cause to believe that the defendant committed this act of manual strangulation. As Dr. Levine testified, manual strangulation, even with the accompanying blunt force trauma, and even with potential fentanyl in the system, takes a minute at the very minimum of constant pressure beyond the point of passing out in order to accomplish. And I think that in and of itself supports the first degree homicide charge. Again, Your Honor, I do believe that the probable cause has been established, and I ask for that.
I'm going to post by another judge. We do know that these people have a history, that they argue, that they may have been violence in the past. But on this particular day, we know very little in the way of details. We know my client that they're depending on my client's statement, just amounts to that he smacked her twice. Didn't say anything about strangulation, didn't say anything about any other details that would lead one to believe that he may have killed her. This is an important part of their case. They interrogated him for 2.5 hours, trying to get more out of him. And he said he took responsibility for smacking her and nothing else. As to everything else, as to the cause of death, and amount of time that the person might have been, the deceased might have been expired, that has nothing to do with my client. They gave a description, they can't give more, we can't give any testimony to this court regarding any cooperation. We don't know of any DNA, we don't know of any neighbors who might have heard an argument or anything along those lines, and for those purposes, I would oppose an indictment.
So one thing we do know for certain, we know that the deceased victim here was the victim of a first-degree murder premeditated, and that Dr. Latterly indicated that she had been strangled to death. And I think we can all agree that it takes a period of time to actually strangle someone to death, to actually choke someone. It's not something that can be done without some kind of reflection. So that much is clear. People have presented this court, however, with a very circumstantial case, and that there were no eyewitnesses to the incident. We just have a previous violent history, a very violent history. In fact, one of the witnesses testified that Miss Davis had been beaten so bad that at one point she could barely walk. And that the defendant that's before this court is responsible for that. So there really not being any direct evidence that the defendant did this. There is circumstantial evidence, and much of it comes from the defendant himself in trying to distance himself from the situation. His story that he just came home and found her in the state that she was in is totally hogwash. So in my mind, there's only one reason that he would be lying about why or how she ended up in the state that she was in. And that's as if he was responsible. His false allegations, as well as his violent history towards her, is consistent with the injuries that caused her demise. It may be razor thin. This isn't a portion of the proceedings that requires proof beyond a reasonable doubt. It requires probable cause. Based on the testimony that I've heard, this court is satisfied that people having the burden of probable cause as it relates to the charges contained in the complaint. Court finds those charges were committed in the city of Detroit. Court finds probable cause to believe this defendant. Defendant will be bound over to Wayne County 3rd Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be October 26, 2023 at 9:00 a.m. Defendant will be remanded to the Wayne County Sheriff.
And we have a pretrial services report.
Thank you very much.
What was that date? 11/26?
Yes, sir.
McCarthy.
I want to see you too.
You want to see me?
Yes. What have you got?
my laptop in my bag for a second.
Okay, now, yeah, right, you're gonna ask me right now. All right. Nothing to do.
Oh, anyway, for you.
Right. Oh, yeah. Like everything. Yeah, I knew we had one of those exactly happening. Yeah. I see, okay. Yes.
Oh, no, I won't go that far, but I think I'm old.
The rivalry. The rivalry.
I'm gonna go home, is what I'm gonna go. I'll see you guys next time. Thank you, Judge.
All right, I'm going.
I have two friends like that, I don't want to be around. They're just so in your face.
So, your name is Ohio State. Congratulations. Down the state. No, state had nothing to do with it. Down the state, like, wait a minute.
No, see, I'll root for Steve. It's against anyone.
I'm with Commissioner State. Whereas with Commissioner State. Because of the country case with Commissioner State.
Yes. Your power is?
Like, hey, lineage with Commissioner State. What is your problem?
Give him a haircut.
It can be.
I'll see you.
All right.
Actually, next Thursday I'll be.
Okay.
Bye, everybody.
Bye. Y'all have a good day. Thank you.
Well, folks, that concludes the docket for today. Hope to see you tomorrow, same bat station, same bat time.